Judge, this is the case, Mr. Wilson.
Okay, thank you. You all may be seated. Mr. Wilson.
Right out the gate, we've got a classic child support modification case, but here's where it gets interesting. When someone asks the court to lower payments, they don't just get a pass. They have to prove a real financial change. So the big question is this a genuine struggle or a strategic move?
You brought this case before the court. What's going on?
Yes, Your Honor. I'm here today to request that the court reduce my child support that I currently pay my ex-wife. Currently, I pay $800 a month, but up until last year, I worked for the city, and now I'm currently self-employed, and I make considerably less money. So I was requesting that my child support be lowered to reflect that.
And just like that major red flag, the opposing party didn't show up. In court, that's not just a no-show, that's a huge tactical mistake. Because when one side is missing, the judge is left hearing only one version of the story. So ask yourself, what would you do in her position? Risk it or show up and fight?
Before we go any further, where is Mrs. White?
I don't know.
You sent her notice that she was supposed to be here today, right?
Yes, she was served.
Okay. So I guess she didn't understand how serious this was today. All right. So you said that you used to work for the city.
Yes.
And now you're self-employed.
Yes, I am.
And what do you do self-employed?
I own a tow truck business company.
Okay. Are you making more money or less money now?
I'm making less money. I have a lot more expenses being self-employed, but I make less money.
All right. All right.
Now, this is where the case gets technical. He's self-employed, which means income isn't always straightforward. Courts don't just take your word for it. They dig into receipts, tax returns, even business expenses. And sometimes what looks like less income on paper doesn't tell the full story. So is he really earning less or just reporting differently?
So based on what you provided to the court, you have some receipts
Yes, I do.
showing what you pay in what daycare expenses. I also see a 1099 here that you have from workers. You have what, 2 employees?
Yes.
Then I'm also seeing a tax return here. Based on this tax return, I have your earnings. It has gone down. It has gone down. I have you at about $3,700 now.
Yes, that's
For
about
gross.
right. I make about $47,000 a year.
All right. So you say you pay $200 a month in health insurance
For him, yes.
and this is for him only, full
Yes.
coverage for only him, not you and him.
Yeah, it's about, with both of us, it's about $450.
Okay. Just want to make sure because you don't get any credit for yourself. It's only credit for health insurance for your son. You
Understood.
understand that, right?
Yes.
Okay. So based on that, I have your net and giving you credit for the $200 that you pay in health insurance for your son. Comes out to about $2,834.23.
And there it is, the moment of truth. The judge recalculates everything and drops the payment from $800 to about $566. That's a significant cut. But here's the key takeaway. This didn't happen just because he asked. It happened because he backed it up with solid evidence. No proof, no reduction. Simple as that.
Which would bring your new child support amount to $566.85.
Okay.
Okay?
Yes.
Mr. Wilson, I do appreciate you being here today and being timely. Thank you. I didn't want you to think that just because Mrs. White decided not to show up today for court, that the court could not move forward. Because in Texas courts, once you are served your own notice with a hearing, you have to appear. And if you do not appear, the other side who's bringing the case does still have the opportunity to ask the court for some sort of relief. So you're here today asking for your child support to be reduced. You submitted evidence to support your stance. She had the opportunity to be here and contest whatever it was that you submitted in court, your 1099s, your tax return, even some of the receipts that you provided. But it was a missed opportunity for her because she decided not to come to court.
Well, this right here is the turning point of the entire case. By not showing up, she essentially gave up her chance to challenge any of his claims. In legal terms, this opens the door to something called a default judgment, where the court can rule in favor of the person who did show up. One absence and the outcome can completely shift.
So in the future, whenever you need to come back to court, maybe to change your order, life change or something like that, just make sure that you always send notice to that other person, because you are able to still receive some sort of relief although they fail to show up. Okay?
Yes, Your Honor.
Is there anything further?
No.
Okay.
Thank
Well,
you.
thank you. You're welcome. You are dismissed.
This case may seem straightforward, but it highlights a powerful reality. Court isn't just about what's true. It's about what you can prove and whether you show up to prove it. One person came prepared, the other didn't even appear, and that made all the difference.